Do prisoners have free speech rights? Can they get access to Dungeons & Dragons, the fantasy board game? Or may the game's Dungeon Master Leader role create the risk of prisoners forming gangs? Can even lunar maps be banned because maps pose a risk of escape? Can books about hydrogen bombs be banned on the theory that prisoners need to be controlled in learning how to make weapons? Are the works of John Updike obscene and thus subject to censorship for prisoners? Sophie's Choice? And no, those are not joke questions. They are actually real cases we will explore today. Can prisoners get pornographic magazines? Can they freely communicate with friends in other prisons? What level of free speech do they get once convicted and behind bars like these? Courts are split, as you will see. Hello and welcome. My name is Peter Afrasiabi. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is on free speech, First Amendment ideas, and prisoners and the prison system, stemming from our Curious Lawyer series. We ultimately ask several questions. First, what level of free speech and First Amendment rights do people give up when incarcerated? Second, what kinds of restrictions can prisons put on speech rights so as to maintain order and discipline, and what counts as a proper prison goal? Third, what is the governing Supreme Court First Amendment test to analyze these questions? So sit back, be grateful you are not incarcerated, and get your curiosity going as we embark on this First Amendment journey into prisons. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true curious lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program, where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times shocking ethics exploration of our judges. The First Amendment is here. Incredible language, short, to the point. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. On its face, it is pretty absolute, and as you recall from law school, Justice Black had a fairly absolutist position on this language. Regardless of that, we have laws restricting speech that are analyzed under a variety of First Amendment tests. So let's get our bearings on the basics of categories of speech that can be regulated. And you guessed it, prisoner speech is one of them. So let's now discuss today's agenda and where we are going. We will start with an overview of the First Amendment, looking at the historical scope and rationale, purpose, and goals of the First Amendment. We will focus today on the free speech clause only, and freedom of religion or free exercise issues. We will look at content and viewpoint restrictions and standards that apply in our modern First Amendment litigation. We will pause to look at the incorporation doctrine as applied to the states, to see how the First Amendment also delimits state restrictions on speech. This will bring us to prisoners and speech, and the issue of shedding of rights at conviction and incarceration, and allow us to explore where prisoners and speech rights fit within our categories of allowable speech restrictions by government. This brings us to the substantive scope and Supreme Court rulings and tests for this lower protection category of prisoner speech. It will allow us to look at Supreme Court case law and also circuit courts cases on prisoner communications, prison limits on speech of prisoners, and the governing framework in the 21st century for the scope of speech rights of prisoners, all in terms of how it plays out in actual practice. Ultimately, we look at government limits on prisoner speech, the existing balancing test, and presumptions on government restrictions. Double-clicking a bit, we will look at prisoner on prisoner speech, as well as prisoner to non-prisoner speech, and see how it plays out in the case law. Similarly, we will look at incoming versus outgoing speech, as well as family and lawyer speech with prisoners. And we will assess First Amendment right to receive publications or engage in jailhouse lawyer speech. And we will see whether prisoners have First Amendment rights to access sexually explicit magazines. Ultimately, we look at the balancing test of driving penological interests to justify various restrictions on prisoner speech. You see here we have the case of State versus Gruber. This is from Maryland in 1819, and this involved a Reverend Gruber, who was a member of the Methodist Episcopal Church, and he preached a sermon at a camp meeting, and this was organized by his Methodist Episcopal Church. And he preached this sermon to around 5,000 white people who were in attendance and around 400-odd slaves. Now, Reverend Gruber criticized slavery as a, quote, national sin, end quote, and said this is contrary to the founding principles of the Republic. In short order, Gruber, Reverend Gruber that is, was arrested and in a criminal indictment. He was charged with attempting to stir up acts of mutiny and rebellion. It's a sort of an old form in essence of incitement, and the incitement speech issues, which have, as we see now, touched the country from the beginning and touch us even to this day. Now, what happened in this case, interestingly, is that a lawyer by the name of Taney, who later became an infamous Supreme Court justice, represented Gruber and secured an actual acquittal in front of the jury on free speech basis. So the case never made its way up to the Supreme Court, but it's an early example of someone engaging in speech that's deemed insightful and likely to cause problems. And also now it's abolitionist speech, obviously, the massive issue of that day in terms of slavery and abolition. But Taney was able to secure an acquittal in front of the jury, saying that the Reverend had the right to engage in that speech by calling slavery an original sin, and that the prosecution was fundamentally improper because he secured an acquittal. Now, what's interesting is that in many southern states, states then started actually passing more specific laws, banning abolitionist literature and speech. And in perhaps great tragic irony, I guess that is the word here perhaps, or just plain tragedy, to the situation this lawyer Taney, who represented Gruber, found himself in. He secured an acquittal of Gruber, allowing him to engage in abolitionist speech. But Taney later, when he was on the Supreme Court, delivered the Supreme Court's infamous Dred Scott decision in 1857. There's an arc across time in our past for you. We're going to look now at a 20th century huge case, and that is Debs versus United States. And this is in 1919, and it'll allow us to look at what is fundamentally incitement speech, to explore categorical definitional purposes and categories of speech that can be limited. It's not a prison case, at least not totally. So Debs was obviously a very well-known public figure. He'd received almost 1 million votes when he ran for president in 1912 on the socialist ticket. And then in 1918, Debs gives a speech outside the Canton, Ohio prison, and he'd been there visiting 3 socialists who were convicted of violating the Sedition Act, and they had been imprisoned. Now, the Sedition Act at issue here provides any disloyal, profane, scurrilous, or abusive language about the government of the United States or the flag of the United States or the uniform of the Army or Navy could be prosecuted. So Debs goes out, he speaks to 12,200 people outside this prison. He offers his support for the prisoners, saying they're paying the price for seeking to pave the way for better conditions for all mankind. He was a pacifist. He condemned the war, but he actually took care not to advocate any illegal activity, and even commented to his audience that he had to be prudent with his word choice. Nonetheless, he was arrested and convicted. He got a 10-year sentence. And he takes this up on appeal to the U.S. Supreme Court, arguing that it violated his First Amendment speech rights. And so let's look on the next slide at what had come down in the exact same term. And that's the well-known case of Schneck. And Schneck is a case, of course, that decided and adopted the clear and present danger test for speech looking at words in context. So, as applied to Debs, a unanimous Supreme Court, as written by Justice Holmes, held that even though Debs did not expressly advocate draft resistance, his intent and the general tendency of his words were together sufficient for a jury to convict him fairly. And in fact, and perhaps tragic irony here too, the Supreme Court even noted that, he had noted in his speech that he had to be careful what he said. And that showed an awareness that he was kind of in the zone of incitement, as opposed to seeing it as a sign of him actually being careful. Now, the same term we had Abrams v. U.S., and this is about 8 months later on, where you have a similar case of several individuals who are convicted of distributing leaflets advocating their political views about the Russian Revolution. They were convicted as offering clear and present danger speech. There, where the conviction was affirmed by the Supreme Court, but this time Holmes issued actually an impassioned dissent. And in dissent, he said those who think they are right will find it perfectly logical to translate their convictions into the law and impose them on others. But it is the theory of our Constitution that the best test of truth is a free trade in ideas. So interestingly, he himself dissenting there, saying that didn't have the same feelings towards Eugene Debs several months earlier. But nonetheless, after 3 years in prison, Eugene Debs' sentence was commuted, but it enabled President Harding to be elected. So Debs wasn't around to interfere with the election. Debs is a prison case in that sense then. He went to prison for his speech on the outside under categorical bans on speech. That probably portends for you where we are going on prison speech on the inside then. Let's take a little quick sidestep here and talk about whether the First Amendment applies to the states. And this is the incorporation doctrine issue. And so the fundamental issue is that we have this idea that the protections of the constitutional amendments in the Bill of Rights had only applied to the federal government at the founding of the Republic. They did not apply to the state governments. And so the question then was raised after the Civil War amendments were adopted as to whether the 14th Amendment's Due Process Clause fundamentally incorporated those 10 amendments by reference and made them basically applicable to state governments. And this sort of question of whether we had this massive new reordering in our constitutional world after the Civil War amendments is answered by this basic test that the Supreme Court's adopted. And that is, they look to figure out whether the rights at issue in the Bill of Rights are fundamental ones rooted in the tradition and conscience of our people and therefore implicit in the concept of ordered liberty. If so, they get incorporated and applied to the states via the 14th Amendment. And that's sort of the test and quote from one of many cases that looks at this test. But the Griswold v. Connecticut case dealing with contraception in the 1960s is one that sort of looks at it. And it's a good case to go look at if you want to get a better sense of the incorporation doctrine. and really all of the Bill of Rights, except a few portions of some of them have been incorporated and adopted. Now, the First Amendment has been one of the cases, is another one of these cases dealing with left-wing manifesto. Here that was Gitlow v. New York, and there you had state prosecution for a left-wing manifesto publication and conviction. The court held it was incorporated and applied to the states. Let's get our bearings on modern First Amendment principles. The court scrutinizes closely any sort of content-based or viewpoint-based speech restrictions. What is a content-based restriction? This is a restriction on speech that is due to the content of the speech. Here is an example: a law that restricts any type of political message from being expressed in a public place. And these get reviewed under strict scrutiny review, making them very hard to survive. Next, what is a viewpoint-based restriction? This is a restriction on speech that is due to the viewpoint expressed by the speaker. Here is an example: any law that restricts someone from expressing a specific political viewpoint, such as support for Donald Trump or Barack Obama. Finally, what are content-neutral laws? Laws that restrict speech in a content-neutral manner are generally analyzed under intermediate scrutiny, in that they must serve to advance an important government purpose and must be substantially related to that purpose. Example: an anti-littering law that does not on its face restrict speech, but incidentally does as a result of its neutral anti-littering application. Let's look at an example of a content-based law in the First Amendment. Here are our facts. In 2005, Gilbert, Arizona adopted a municipal sign ordinance that regulated the manner in which signs could be displayed in public areas. The ordinance imposed stricter limitations on signs advertising religious services than signs that displayed political or ideological messages. A local church would post signs on Sunday about the services and its church. It was then cited for violating the ordinance. The court held that the town's sign ordinance imposed content-based restrictions that did not survive strict scrutiny because the ordinance was not narrowly tailored to further a compelling government interest. Justice Thomas's unanimous opinion also clarified that strict scrutiny should always be applied when a law is content-based on its face. Now let us turn to an example of a law that is one that shows a viewpoint-based example. This brings us to a rock band. Here are the facts. An Asian American band wanted to register, quote, slants, end quote, as their name. It was as the band explained an act of reappropriating a slur to drain it of its historical negativity. The trademark office denied federal trademark on the word as it was disparaging, and such marks that may disparage cannot be registered under the Lanham Act. The Supreme Court held as follows: denying trademarks that are disparaging is a viewpoint restriction that fails the First Amendment. In short, it cannot reject a mark because of viewpoint it espouses. Here is the language. Our cases use the term viewpoint discrimination in a broad sense, and in that sense, the disparagement clause discriminates on the basis of viewpoint. To be sure, the clause even-handedly prohibits disparagement of all groups. It applies equally to marks that damn Democrats and Republicans, capitalists and socialists, and those arrayed on both sides of every possible issue. It denies registration to any mark that is offensive to a substantial percentage of the members of any group. But in the sense relevant here, that is viewpoint discrimination. Giving offense is a viewpoint. We have said time and again that the public expression of ideas may not be prohibited merely because the ideas are themselves offensive to some of their hearers. End quote. That is at page 22 and 23 and is a key framing of how viewpoint laws fall. So notwithstanding Justice Black's statements or the textual language, here are categories of less or unprotected speech. Incitement to violent speech, threats or fighting word speech, obscenity, lying. There are limits on one's right to lie, such as perjury standards of obstruction charges when speaking to the FBI, for example. Defamation is less protected speech, of course, and may be punished by state judicial issuance of judgments. School speech standards allow for regulations. And yes, prisoners in prison speech is a category, and today it is our category to now dive into. The governing test is known as the Turner test from this case. Turner v. Safley, 482 U.S. Report 78 from 1987. The basic facts. Missouri establishes a rule that limited prisoner communications due to mails being used to formulate breakout plans and limiting communication. This was done to help solve growing gang problems, as found by prison. How did that rule delimiting speech get applied? Let's start with a framing principle. Prison walls do not form a barrier separating prison inmates from the protections of the Constitution. Hence, for example, prisoners retain the constitutional right to petition the government for the redress of grievances. They are protected against invidious racial discrimination by the Equal Protection Clause of the 14th Amendment, and they enjoy the protections of due process. Because prisoners retain these rights, when a prison regulation or practice offends a fundamental constitutional guarantee, federal courts will discharge their duty to protect constitutional rights. But courts are ill-equipped to deal with the increasingly urgent problems of prison administration and reform. The problems of prisons in America are complex and intractable, and more to the point, they are not readily susceptible of resolution by decree. Running a prison is an inordinately difficult undertaking that requires expertise, planning, and the commitment of resources, all of which are peculiarly within the province of the legislative and executive branches of government. Prison administration is, moreover, a task that has been committed to the responsibility of those branches, and separation of powers concerns counsel a policy of judicial restraint. Where a state penal system is involved, federal courts have, as we indicated in Martinez, additional reason to accord deference to the appropriate prison authorities. So given that real-world concern, the solution is as follows. A balancing test of reduced scrutiny standard for restrictions on prisoner speech. So let us now get the specific test that balances a prisoner's speech rights against the prison's need to maintain order for those incarcerated. The Supreme Court settled on a four-factor test, and here you can see the four factors. Let's look at them one by one. 1. There must be a valid, rational connection between the prison regulation and the legitimate governmental interest put forward to justify it. Cannot be so remote as to be arbitrary. 2. Whether there are alternative means of exercising the right that remain open to prison inmates. If so, courts need to defer more to prison officials. 3. The impact accommodation of the asserted constitutional right will have on guards and other inmates, and on the allocation of prison resources generally. 4. The absence of ready alternatives is evidence of the reasonableness of a prison regulation. This is not a least restrictive alternative test. Prison officials do not have to set up and then shoot down every conceivable alternative method of accommodating a prisoner's speech complaint. So that test was applied in the case in a 5-4 ruling, and let's see how it played out. It permits such correspondence with immediate family members who are inmates in other correctional institutions, and it permits correspondence between inmates concerning legal matters. Other correspondence between inmates, however, is permitted only if the classification treatment team of each inmate deems it in the best interest of the parties involved. Thus, this Missouri rule limited prisoner communication due to mails being used to formulate breakout plans, and limiting communication helps solve growing gang problem, as found by prison. The Supreme Court found that it met the four-factor test, and so prisoner communication could be limited. It was a logically connected rule to legitimate penological security concerns, and it only limits communications with certain people with no other obvious and easy alternative exists. That is the framework that applies to this day. So let's see some other cases applying the Turner four-factor test. Here we have a Federal Bureau of Prisons regulations that generally permitted prisoners to receive publications from the outside. But it also authorized wardens, pursuant to specified criteria, to reject an incoming publication if it is found to be detrimental to the security, good order, or discipline of the institution, or if it might facilitate criminal activity. Now, wardens may not reject a publication solely because its content is religious, philosophical, political, social, sexual, or unpopular or repugnant, or establish an excluded list of publications, but must review each issue of a subscription separately. In this case, respondents, a class of inmates and certain publishers, filed suit in the district court, claiming that the regulations, both on their face and as applied to 46 specifically excluded publications, violated their First Amendment rights. This is the case of Thornburg versus Abbott at 490 U.S., reports 401 in 1989. Let's see how it played out. The Supreme Court ruled as follows. The regulations at issue are facially valid under the Turner Standard. Their underlying objective of protecting prison security is undoubtedly legitimate and is neutral with regard to the content of the expression regulated. Also, the broad discretion the regulations accord wardens is rationally related to security interests. Furthermore, alternative means of expression remain open to the inmates, since the regulations permit a broad range of publications to be sent, received, and read, even though specific publications are prohibited.
Moreover, challengers have established no alternative to the regulations that would accommodate prisoners' constitutional rights at a de minimis cost to valid penological interests.
Thus, legitimate penological interests existed to deny prisoners access to certain kinds of materials and publications. Of course, these standards are contra to the rest of society. There is little doubt that the kind of censorship just described would raise grave First Amendment concerns outside the prison context. In this case, there is no question that publishers who wish to communicate with those who, through subscription, willingly seek their point of view, have a legitimate First Amendment interest in access to prisoners. The question here, as it has been in our previous First Amendment cases in this area, is what standard of review this court should apply to prison regulations limiting that access. Thus, to remain clear, these are content-specific restrictions in a realm outside normal operating principles of the First Amendment.
But this ruling in Abbott was not unanimous.
Let's look at our three dissenters. And it is worth starting with Stephen's dissent, as it opens this way, quoting an article in Labyrinth. That is a magazine published by the Committee for Prisoner Humanity and Justice, and this is an article a prisoner was denied access to by the rule. Quote, in January 1975, William Lowe, a black prisoner at the United States Penitentiary at Terre Haute, Indiana, died of asthma. In August 1975, Joseph Jones, Jr., a black prisoner at the U.S. Penitentiary Terre Haute, IN, died of asthma. The prison infirmary at that time had only one respirator, known to be inoperative in January 1975, when William Lowe died.
It was still broken in August 1975 when Joseph Jones needed it.
On the day of his death, Jones was suffering an acute asthma attack. He was gasping for breath in the stale, hot, humid air in the cell. He requested medical aid of the guards. After several hours of unheeded pleading, accompanied by complaints to the guards from fellow prisoners in the cell block, Jones became frantic. Each breath was painful. Each breath brought him closer to suffocation. Finally, guards called the physician's assistant, who brought with him the broken respirator. Finding the equipment unusable, the PA gave Jones an injection of the tranquilizer, Thorazine, to calm him. Treatment with a tranquilizer was unquestionably contraindicated by Jones's medical condition. 20 minutes later, Jones was dead. Conclusion: Jones, who was convicted of bank robbery and sentenced to 10 years in prison, was in fact sentenced to death and was murdered by neglect. End quote. That is a powerful opening to a dissent and shows the type of material at issue that raised for the dissenters concerns about why important facts and articles were being denied to prisoners. And the dissenters rejected the idea that the prison needed to deny access to this material in order to maintain prison order or some other penological interest.
Thus, for our three dissenters, if a prison official deems part of a publication's content, even just one page of a book, to present an intolerable security risk, the Bureau's regulations authorize the official to return the entire issue to the publisher.
There is no evidence that delivery of only part of a publication would endanger prison security. and specifically as they write. Speech concerning public affairs is more than self-expression. It is the essence of self-government. The First and 14th Amendments embody our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials, end quote. But their view did not carry the day, and it would be over a decade before the Supremes again considered the Turner test. This brings us now to 2001. This is Shaw versus Murphy from 2001. The facts. While Kevin Murphy was incarcerated at the Montana State Prison, he served as an inmate law clerk, providing legal assistance to fellow prisoners. Upon learning that inmate Pat Tracy had been charged with assaulting correctional officer Glenn Gailey, Murphy decided to assist Tracy with his defense. Prison rules prohibited Murphy's assignment to the case, but he nonetheless investigated the assault. After discovering that other inmates had complained about Officer Gal's conduct, Murphy sent Tracy a letter. Prison intercepted and punished Murphy for violations of the prison's rules, prohibiting insolence, interference with due process hearings, and conduct that disrupts or interferes with the security and orderly operation of the institution. He challenged the interference. Here is what the Supreme Court ruled. Augmenting First Amendment protection for inmate legal advice would undermine prison officials' ability to address the complex and intractable problems of prison administration. The Turner test applies and was met. Murphy is incorrect in his assumption that there is a freestanding right to receive legal advice. This was a unanimous decision, no less, too. And now let's go forward half a decade to 2006. Here we have a Pennsylvania policy that denied access to newspapers, magazines, and personal photographs for certain classes of prisoners deemed recalcitrant and incorrigible to motivate better behavior by providing them with an incentive to move to lower security levels. This is the case of Beard versus Banks, and you have the citation there. Let's listen to the oral argument to hear the issues of the restriction on books and newspapers and why and how they are used as weapons. You will hear Justices Scalia, Ginsburg, and Roberts push hard to understand the rationale, and then you will hear the lawyer for the prison and state explain the danger. So here we go.
Is this one of the most severe restrictions in the nation with respect to reading material and photographs?
I'm sure that it is.
What is the reason that the state or the regulations allow paperbacks from the library and not current events? The rationality of that line escapes me.
Well, there's certainly a security component to it. Paperback books, small, compact, much more difficult to use as weapons, and the experience of the prison staff that operate this high security unit is that newspapers and magazines have been a frequent source of mischief.
Okay, can you explain that? How do one use a newspaper as a weapon? I mean, maybe disciplining a dog or something.
Actually, inmates, particularly the worst of the worst, are quite clever at using newspapers. A newspaper rolled tightly with toothpaste used as an adhesive can be compacted into very nearly the equivalent of a nightstick.
Huh. But a paperback version of War and Peace is less dangerous? It seems
The experience of prison officials is that, yes, it is, and actually it's very common in prison systems to distinguish, for example, between hardback books and paperbacks. These are difficult lines to draw, and that's where the professional expertise of the people who deal with the problems every day comes into play.
But if the concern is the safety concern, then you would have an equal concern with the Jewish Daily Forward, which is a newspaper format. Right, I don't know what the Watchtower comes out in these days.
Yes. Well, Justice Ginsburg, the experience of prison administrators is that prisoners are less likely to use religious and legal materials for mischief. And as to paperbacks as well, they do supply an alternative means of receiving information from outside the prison. But again, if I allude frequently to the experience of prison administrators, it's because that's what this policy is guided by. Newspapers and magazines have a high value to inmates.
Well, that's why I thought your answer would have focused on that rather than the security concerns, is that you take away what it is they want the most, because that's most likely to result in them conforming their behavior so they can get it back.
Yes, and that is as the primary purpose of the policy overall.
So there you have the court pushing on the state. But what did the Supreme Court ultimately hold about that prison policy? It held that prison officials provided legal support for a policy denying newspapers, magazines, and photographs to inmates. Turner was met because the prison had a need to maintain the prison order. Again, we had a dissent. You see here what the dissent said. It is indisputable that this prohibition on the possession of newspapers and photographs infringes upon respondents' First Amendment rights. The state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge. The right of freedom of speech and press includes not only the right to utter or print, but the right to distribute, the right to receive, the right to read, and freedom of inquiry, freedom of thought. At root, the dissenters felt the prison failed to demonstrate that the prohibition on newspapers, magazines, and photographs is likely to have any marginal effect on security. But they lost, and so we now see a clear through line on the Supreme Court treatment of the Turner test. Prison speech may be limited quite easily by prisons as long as it drives some rational prison policy of security, safety, or other penological interests. It's a low-bar test for prisons, in other words, to impose speech restrictions on prisoners. So let us now go down a notch to the circuit appellate courts to see how they handle these cases.
Before we get to circuit courts applying Turner, let's look at one case involving literary restrictions. Here we have Klein v. Fox, a district court case from West Virginia. The district court considered a policy purge of a prison library, which resulted in the removal of 259 books, which constituted obscene material. Prison staff were instructed to read every book in the library and to eliminate any book that contained language that might arouse the reader. The subsequent purge included William Styron's Sophie's Choice, Gore Vidal's Myra Breckenridge, and a number of works by John Updike. Because the prison rule necessarily included the Bible and Orwell's 1984, the district court found it violated Turner and was way overbroad. And here is the lasting quote. In view of the library regulation's substantial overbreadth and incongruities, the court cannot find any logical connection between the policy directive and its intended goals. To curtail sexual assaults, the regulation presumptively prohibits the Canterbury Tales, but welcomes Playboy. So there is a win for John Updike's works and an example of a policy that goes too far. Let's now see circuit court cases that do not go too far most of the time. So we start in the Fifth Circuit. This is the case of Marino v. Mirano. Basic facts are as follows. Inmate studying cybersecurity was denied receipt of books teaching computer hacking under a regulation that prohibited receipt of publications detrimental to security. He argued the e-regulation violated the First Amendment because he did not intend to use the books for bad purposes and further lacked internet access anyway. The Fifth Circuit held that officials were due deference in their determination that the books posed a security risk inside prison walls and hacking risk was not limited to networked computers. Let's pivot to the Ninth Circuit now and see how things play out here in the Ninth where I live. This gives us the Frost case from 1999. There, a prisoner sued on basis of denial to magazines including Penthouse. The Ninth Circuit held that prison authorities cannot rely on general or conclusory assertions to support their policies. Rather, they must first identify the specific penological interests involved and then demonstrate both that those specific interests are the actual basis for their policies, and that the policies are reasonably related to the furtherance of the identified interests. An evidentiary showing is required as to each point. Actual proof is required from prison as a result. Okay, so pause there as you can see a big difference. Porn in prison may be allowed in the Ninth Circuit unless the prison can really explain how limiting porn serves a purpose. And here's the key difference as these cases play out in the courts. The Ninth Circuit allows common sense ideas or arguments to refute rational prison interest, and thereby shift burden back to prison to show the connection between the policy and restriction is not arbitrary or irrational. It gives slightly more opening to a prisoner to make out a claim, whereas the Fifth and other circuits defer to the face of logic of prison policy and do not allow such a look under the hood, so to speak. Let's now explore porn in prisons further. This takes us to the Third Circuit and the D.C. Circuit. First, the Third Circuit. Here we have Ramirez versus Pugh from 2004. The facts are these. The Federal Ensign Amendment, a law that bans federal prison inmates from receiving material that is sexually explicit or features nudity. This law is challenged by prisoners. The court held that limits on access to porn may be acceptable if after an evidentiary hearing courts can find a connection between the denial of the sexually explicit material and the goal of rehabilitation. Now let's see the D.C. Circuit in action on this. Here are the facts of this 1998 case. Plaintiffs are 3 inmates who were denied the receipt of Playboy and Penthouse. Unhappy, they filed suits alleging that the Ensign Amendment violated their First Amendment rights. The D.C. Circuit held that the Ensign law satisfied the Turner test based on the reasonableness of asserted interest and common sense, and so the government can link bans on pornography to rehabilitative values within prisons. So we have the D.C. 3rd and 9th on porn, and it seems the D.C. is most restrictive, deferring outright, and the 3rd and 9th Circuit want a little discovery to figure out if banning porn makes sense.
Other circuits agree it turns out that restricting access to pornography can meet legitimate penological interests. The Second Circuit has held the same. It found that limits are reasonably related to legitimate penological objectives, namely, promoting a non-hostile work environment for DOC staff, enhancing the safety and security of DOC facilities, and facilitating the rehabilitation of sex offender inmates. Thus, the limits pass constitutional muster. That was the case of Reynolds versus Quiroz at 25 Fahrenheit 472 from 2022. They sought Supreme Court review in 2022, but the Supreme Court denied review in 2023, leaving in place the Turner test for us, and the Turner test as allowing prisons to justify denials of access to sexually explicit materials.
Now we go from porn to phone caps on the amount of minutes for phone calls. Again, we are in the Ninth Circuit. Our facts. A 300-minute cap on prisoner calls. The prisoner challenge as violating the First Amendment Turner test. Their case is dismissed at the Rule 12 stage on the basis that the prison had the right to do so. The Ninth Circuit reversed because there should not be a rush to do a Turner analysis. That is, fact development is needed to know if the articulated basis for the policy indeed was a legitimate penological interest. Thus, it denied the ability of a prison to just get a case tossed out of the gate and wanted some development of the fact record. Now don't confuse all this with the idea that the Ninth is easy on prisoners. Look at the Lampert case at 356, F. 3rd 969 from 2004. There, at summary judgment, a prison policy denying access to sexually explicit material was upheld on a fact record justifying the policy as related to a penological interest. So, with a little factual development, prisons, I guess, can justify denying porn access. Let's go the moon now. It is obviously common for prisons to prohibit access to maps because they may prove useful to prisoners who manage to escape from the walls of their institution. But a New York prison took this concern to even lunar maps. It deemed all maps to present risks of escape, and pursuant to this edict, maps of the moon and other planets were removed from the prison library.
This fact was given the Supreme Court in an amicus brief by the Correctional Association of New York in the Abbott case we discussed earlier, when it explained to the court the levels to which prisons go to so as to control the prison in the NMAE of safety. What if we go one step further and have a denial of speech rights without any explained basis? Can a prisoner sue and a court just dismiss at Rule 12 because Turner is so deferential that it allows any prison denial to be deemed logical or rational? This is the Daniels case in the Ninth Circuit, and in full disclosure, I did this appeal with my law students in our appellate litigation clinic at the UC Irvine School of Law. In this case, the plaintiff prisoner was allowed to communicate with another prisoner in a different prison, but the other one was denied a right to communicate with the plaintiff. Then the other one was allowed, but now the plaintiff was denied. Plaintiff appealed in prison to Prion authorities, but the only reason offered was a citation to regulatory code that allows in circumstances speech restriction. No explanation of why that was cited was given. Here is the code. Quote, "The most restrictive a facility can be with respect to incarcerated person male privileges is to limit correspondence between incarcerated persons to only the following. 1. Immediate family members as defined in Section 3000. 2. Co-litigants on active cases until the case is resolved. 3. Incarcerated natural parent of the incarcerated person's child." End quote. The district court dismissed at Rule 12 and held the Turner test was met. This was then appealed to the Ninth Circuit by the pro se plaintiff prisoner. And as I noted, I took this case and with my 2 law students on this team for this appeal briefed it, and then the students actually got to argue it as certified admitted law students. So let us now start and watch our students argue and then the state attorney argue so you can see the framing of the issues for the Ninth Circuit before we get to the actual ruling of the Ninth Circuit. We will start with the arguments framed by the appellant, and here again, in full disclaimer, you will see my students arguing this appeal, as this is a case I litigated with students in the UC Irvine Appellate Litigation Clinic. So let's start with appellant's argument and issue framing.
This is a very narrow issue. Dismissal at Rule 12b6 is erroneous due to the fact that there is not a sufficient factual record to conduct a Turner analysis based on these facts. The court has held that in Tiedemann v. Blackensee, a sufficient factual record is required to begin to conduct any sort of Turner analysis on the 4-factor Turner test. At this case, we do not have a sufficient factual record. What we do know on this case is that Norma Daniels was at one point allowed to communicate with Mr. O'Neill. He asked to correspond with Mr. O'Neill. They then denied his correspondence. When he asked why this denial happened, they simply cited to 3139F, a regulation that merely tells the facility the restrictions they can place on speech, rather than giving them any sort of mechanism to do so. He sent this appeal multiple times, and multiple times they kept citing to 3139F. That is the factual record, John.
And here is the government's response arguments and position. Listen to this, and then we will see how the court came down.
Please the court, Deputy Attorney General Ari Sheps for defendants. This case concerns inmate-to-inmate correspondence and is directly governed by Turner v. Safely, which Supreme Court upheld a prison policy that restricted communication between inmates at different institutions, yet provided that discretionary exceptions could be made upon an inmate's request. California's regulation, Section 3139, is nearly identical to the one in Turner. Now, Supreme Court in Turner held that limiting communications between inmates who are not family members or joint litigants is reasonably related to legitimate penological interest of safety and institutional
Are you
order.
suggesting that's a bright line rule from Taylor? That means that a correctional facility can always just restrict correspondence under these circumstances?
So, yes, we would say that it is a bright line rule that restricting communications between felons or individuals on parole, not felons, individuals who are incarcerated, is bright line and protected by Turner because of the inherent security concerns, which, as the court stated, the prohibition on correspondence between institutions is logically connected to these legitimate security concerns.
But didn't the court in Turner list some factors to consider
Yes, the court did list
So
factors.
why do we consider factors if it's a bright line rule? Won't we just say it's correspondence between two inmates, it's done?
Well, so the factors allowed in Turner are the restrictions for limiting all kinds of speech. They're evaluated in multiple contexts, and one of those factors is there a legitimate penological interest? But as it comes to inmate communication, the legitimate penological interest is inherent in the fact that you have two inmates at different communications institutions that are communicating. That itself is a safety concern.
So are you arguing that, or are you saying that Turner holds, among other things, that a prison can always, without more, restrict inmate-to-inmate communications, even at other institutions, without having to show anything, without having to show any particular reason, just because of the inherent nature of inmate-to-inmate communications? They don't have to, but they could allow it, but they could restrict it without showing any more. Is that what you're saying Turner holds?
Well, I would say that Turner holds that you don't need additional justifications beyond the inherent safety considerations.
So that was a spirited argument, and you see the fault lines. And the plaintiff prevailed, which I can happily note since my students argued it. Here's what the Ninth Circuit ruled in its decision. First, it said, quote, "We conclude that Daniels has adequately alleged a violation of his First Amendment rights and that dismissal under Turner was improper. First, defendants have not established a valid general ban on inmate correspondence. What the regulation does not do is create a general ban on all inmate-to-inmate correspondence except for immediate family members, co-litigants, or natural parents of an inmate's child. Thus, the fact that the regulation may permit a facility to enact a general ban if it can satisfy Turner's four-factor test does not assist the defendants here when the relevant facility has not done so. Finally, the court noted that viewing Daniels' complaint in the light most favorable to him, his allegations of inconsistent application are sufficient to survive the pleading stage. The case then was reversed and remanded for discovery into what happened and why. Yes, you heard that right. One prison banned the board game, Dungeons and Dragons. Now, when I was a kid and we played that, we were called nerds for playing it. If there is a sound penological interest for dealing with prisoners, it strikes me that pushing them to become nerds is not a bad one. But alas, let's see what happened in the Seventh Circuit case of Singer versus Ramish when prison officials turned their gaze to the game. Inmate Kevin Singer liked Dungeons and Dragons, and for years he ordered and received Dungeons and Dragons materials while in prison. But the prison employed a gang specialist who received an anonymous letter from another prisoner suggesting that Singer was attempting to form a gang centered on Dungeons and Dragons. Alarmed about the gang of nerds playing the fantasy game, and apparently trusting the letter for the truth of its matter, the prison confiscated Singer's materials and said that going forward, inmates are not allowed to engage in or possess written material that details rules, codes, dogma of games or activities such as Dungeons and Dragons because it promotes fantasy role-playing, competitive hostility, violence, addictive escape behaviors, and possible gambling. Yep, you heard that right. Singer obtained affidavits from 11 prisoners and 3 experts in role-playing games, all of which made clear, like what seems obvious, that playing Dungeons and Dragons bears no relationship to gang activity or escape plans. The prison official said cooperative games can mimic escape or gang plans because they are doing things together in a group. So what did the court hold? The Seventh Circuit applied the Turner test we have seen, and concluded that Dungeons and Dragons was indeed verboten stuff. Let's unpackage now the holding specifically. The prison gang specialist explained that the policy was intended to promote prison security because cooperative games can mimic the organization of gangs and lead to the actual development thereof. At bottom, his testimony about this policy aim highlighted the prison worries about cooperative activity among inmates, particularly that carried out in an organized, hierarchical fashion, akin to a gang. But loads of witnesses testified to the contrary. So how did the Seventh Circuit manage that collision? It held, quote, "It is true that Singer procured an impressive trove of affidavit testimony, including some from role-playing game experts, but none of his affiant's testimony addressed the inquiry at issue here. The question is not whether D&D has led to gang behavior in the past. The prison officials concede that it is not. The question is whether the prison officials are rational in their belief that, if left unchecked, D&D could lead to gang behavior among inmates and undermine prison security in the future. Thus, the court continued, quote, "Once the prison officials provided the court with a plausible explanation for the D&D policy, that the game's structure, especially its control by the dungeon master, mimicked that of gangs, and could consequently promote gang development and undermine prison security, the burden shifted to Singer to present evidence to call that explanation into question." Singer, however, failed to respond directly to the prison's concern about D&D players looking to dungeon masters, rather than to the prison's own carefully constructed hierarchy of authority for guidance and dispute resolution. Instead, his affiants simply assert that D&D has not to their knowledge incited prison violence or motivated devotees to form a stereotypical street or prison gang. End quote. So the bottom line is this. The game involves a hierarchical structure. Gangs have such structures. Players of the game may become gang-like in their mindset and no longer look to the warden as the prison authority on prison matters, and instead the game's dungeon master may become a powerful force in a prison. If it sounds sort of ridiculous, well, it kind of is seemingly ridiculous. It's quite hard to understand how, when the prisoner gave even expert testimony that the game is not associated with gangs and that the game can improve inmate rehabilitation, how in that case the prison still could ban it on a theoretical musing. But that is the point of the law here. Rights are very curtailed and deep deference is given prison administrators. Thus, this Seventh Circuit case shows you how extremely deferential the courts are. The same amicus brief, the one we looked at earlier, also detailed how a Wisconsin prison banned prisoners from receiving the magazine called The Progressive, based on a prison policy about not allowing inmates access to material about weapon building. Now, I get the policy about weapons, but I am doubtful that prisoners are making hydrogen bombs anytime soon, regardless of what they read. We started with a broad overview of the First Amendment tests on content-level restrictions and categories of speech that can be limited by the state. And of course, if you want a deeper dive into the First Amendment, we have two specific programs for you. First, from our Bill of Rights series, we have one whole hour devoted to an overview of the First Amendment. And then we have a second one on hate speech within the First Amendment looking at hate speech law and cases. But that aside, here you got mini overview to start. We looked at several Supreme Court case Sandsaw broadly deep Supreme Court deference. The decisions were 5-4, then 6-3. One was 9-0, and then 6-2 over the 1987 to 2006 period. Those are the Supreme Court rulings we assessed, and we saw at root that there is wide deference given prison administrators to limit speech. On the merits, we looked at the well-solidified deferential test that allows restrictions on prisoner First Amendment rights were rationally related to legitimate penological interest. That four-factor test is highly deferential in words and implementation. It's known as the Turner test, and just to recap, the four factors again are: 1. There must be a valid rational connection between the prison regulation and the legitimate governmental interest put forward to justify it. Cannot be so remote as to be arbitrary. 2. Whether there are alternative means of exercising the right that remain open to prison inmates. If so, courts need to defer more to prison officials. 3. The impact accommodation of the asserted constitutional right will have on guards and other inmates, and on the allocation of prison resources generally. 4. The absence of ready alternatives is evidence of the reasonableness of a prison regulation. This is not a least restrictive alternative test. Prison officials do not have to set up and then shoot down every conceivable alternative method of accommodating a prisoner speech complaint. At root, we saw it as almost insurmountable for a prisoner to win ultimately and challenge what is a valid rational prison interest. Circuits vary in level of deference given and burden on prison to produce evidence to support its reason. But we also saw how even with testimony that board games like Dungeons and Dragons pose no risk, a prison was allowed to conclude otherwise on its conjecture that the game may invoke gang-like structures. We saw the Ninth Circuit is seemingly the most pro-prisoner friendly in terms of pushing for more facts to support the prison interest and allowing cases to survive Rule 12 challenges. That is, that while the Turner test is highly deferential, there is an ability to at least look properly under the hood of it to make sure that the articulated prison reason or interest is logical and rational. This is in distinction to just assuming the prison's articulated reason is fair and right. Thus, we do see that the amount of logic or actual facts to support a given prison policy is actually something dividing the circuit's courts in resolving cases, leading cases to survive Rule 12 in Ninth Circuit more easily than perhaps other circuits. And along the way, we listened to some oral arguments framing these prisoner First Amendment cases. So, I hope you enjoyed our program. Stay curious, and as always, if you have any questions, please reach out to me.